Labour Party has rejected the judgment of a federal high court in Kano, declaring votes scored by the governor-elect of Abia State, Alex Otti, as a waste. In a statement, the party described the judgment as inconsequential and laughable, adding that it holds no water. The party argues that the court lacks the jurisdiction to entertain an election matter at a time when elections have since been concluded and winners emerged. The acting National Publicity Secretary of the party, Obiora, says the ruling is the handiwork of suspended members of the party loyal to the acting Deputy National Chairman, Lamidi Akpakpa. The judgment issued by MN Yunusa also affects all Labour Party candidates in Kano and Abia states. The judge held that the emergence of the Labour Party candidates in Abia and Kano states was not in compliance with the provisions of the 2022 Electoral Act. He said the emergence of the candidates breached legal provisions that require the party to submit its membership registers to the Independent National Electoral Commission, INEC, within 30 days before conducting its primary elections ahead of the 2023 general elections. To make sense of these latest developments, we now being joined by by Frank Tietie, who is Arise News in-house legal analyst, and pretty much later I'll be joined by the Labour Party's Kehinde Edun to make clear this. Frank, good to see you. You know, some of the key concerns going across a lot of Nigerians will be this particular judgment. Explain it to people in lucid terms, because there seemed to be a lot of misunderstanding about this news. Now, help us make sense of what this Kano judgment concerning Labour Party and its candidate in Kano and Abia State is about.
You know, anytime there is a doubt about what is the law and what is the interpretation of any section of a statute or the Constitution or any written agreement, you actually approach the court with a procedure known as originating summons, for the court to simply state what the state of the law is, or with regards to the proper insight or interpretation as to that provision. In this case, the provision is section 77, subsection 3, that requires a political party to submit the list of its candidate, a list of its members to INEC within 30 days before it holds its primaries. And that, as a matter of fact, that was brought before the court, the Labour Party didn't do with regards to Kano State and with regards to all other states, including the entire 36 states actually, but with specific concern to Kano State and Abia State. Now, it's important that we at all times respect whatever the court proclaims. It doesn't matter whether you like it, whether it affects you negatively or not. In this case, the court looked at whatever was submitted to it, which it's constitutionally bound to do, and makes a declaration, not necessarily an order. A declaration, just the way it is, it states the law, that this is the way the law is.
Just the way you're stating it now.
Exactly. And then it says that if any party, particularly Labour Party, does not comply with that particular provision, it means that whatever that proceeds from a primary election that it conducted will be null and void, and such votes will be wasted. It didn't go further than that. And that is the way it is. It refused to make further consequential orders. For example, it didn't have to declare the election of any candidate to be null and void. He also didn't have to declare that consequent upon the failure of the party to comply with that provision, and as such, it means another person should replace the other person or the other. No. So thankfully, the court simply just gave an elucidation of the state of the law with regards to compliance. But I must add quickly, because when we talk about compliance and we look at it with a stricto sensu approach, it will not be appropriate, because we argue all the time considering section 135 of the Electoral Act that keeps talking about substantial compliance, that INEC, for example, needs not totally comply with every scintilla of the electoral provisions, Electoral Act, and that so long as it makes some mistakes, but it substantially complies with all the provisions, and so no election can be declared void in that case. So you can't be holding these standards and then simply say, because a political party did not submit the list of its candidates to which it can actually submit subsequently, and then you cancel primary elections that have been conducted with billions of naira. A court reasonably doesn't do that. But what it has done is to, serve as a warning to legal officers of political parties that they need to man their departments very well. They need to get young lawyers to read between the lines of these laws, and then they create checklists for these political parties, because it's a misnomer and it's actually a minus for a political party to overlook such fundamental things like submitting the list of members to INEC within the time frame.
I think you've stated this, and I think we'll wait to hear from the National Legal Advisor, because the way you've made it look so simple, perhaps, politicians, as they say, they think quite differently. Even if you're a lawyer and advisor in a political party, you should also sometimes think differently. In this case now, stretching it, the candidates that have emerged victorious in the affected states, you say the court didn't say anything explicitly about their
Absolutely
victory.
Nothing. Take, for example, the person that should have been most worried, Alex Otti, is not, because he's covered by the legal processes, and particularly by the Electoral Act. He's been declared the winner of the elections in Abia State. He's been given the certificate of return. Now, the provisions of Section 138 of the Electoral Act, very fantastic position, which is peculiar to Nigeria, is that anybody who has been declared a winner of any election should go ahead to be sworn in, irrespective of even if a court declares that his election is void. Even if he has been sacked expressly by a court, the law says that so long as he files an appeal within the time limit of 21 days, he is entitled to enjoy the benefits of the office. That is, Alex Otti would be sworn in on May 29, and then he will continue to remain as governor until he dispenses with any appeal that, challenges his election.
Right.
In this case, this really doesn't challenge his election expressly, because no order was made. However, the court is very clear that the Labour Party was at fault and has breached the Electoral Act, and has actually also stated the consequences of breaching the Electoral Act.
Speaking of which, now, let's look at what's happening now. At the moment, we have the election tribunals going on, and now this is another court in Kano. So doesn't this also look as if there is a usurpation of the electoral tribunals?
I don't think so, and that it is not so. There are pre-election matters that can be filed within 14 days after the happening of any action that, borders on the Electoral Act or electoral process. Now, in this case, any Nigerian has a right to approach a Nigerian court to interpret the law. That is what the judiciary does, nothing more than that. So what has happened in this case is that Ibrahim Haruna, an individual, has approached the court to say, please tell us whether or not the failure of Labour Party to comply with the provisions of Section 77, subsection 3, affects this to this extent that what happened, whatever emanated from the primary elections that were conducted in non-compliance with Section 77 are void. And then the court simply agreed with him and stated it so. But what consequences? Of what consequences would that be? Nothing much, because the court actually, the legal process is like this. When you approach a court for a declaration to state what the law is, and then you support that with a set of facts in the affidavit, now you also ask the court to make an order based on the state of the law. Now, those consequential orders, those orders that would have been based on the state of the law, were not made by the court. So it's maybe disrespectful to say that, to address a court that what it has done is a nullity or whatever. However, as a matter of fact, it goes to no issue, and nothing actually significant will affect the fortunes of those persons in Labour Party that have emerged as winners.
This also looks like, even if you've said it doesn't affect the candidates, but again, it looks more like the grand norm. And you're talking about the base. The base is the candidacy and the candidature of these people. So if the court is faulting the candidates, if you stretch it, it will seem as if the candidature of these people in these states are questioned by the court, it then means that perhaps some other things that they may have done thereafter is also questionable.
There is no doubt about the fact that the court has blamed the Labour Party, faulted the Labour Party for failing to comply with that provision. What is the consequence is what we are discussing. Does it affect Alex Otti's victory in the governorship polls of Abia State? No. However, it states clearly, perhaps for subsequent elections, that if you fail to do such and such a thing, you will be in breach of the Electoral Act, and that is capable of actually robbing you of your victory. I must tell you, if that was filed as a pre-election matter by the right parties, particularly persons who participated in the primaries, asking that the court should set aside the outcome of the primaries of Labour Party across the country, it would have been valid, it would have had consequences, and as a matter of fact, even after they approached the Supreme Court, there would be the danger that Alex Otti and perhaps other successful Labour Party members in the various elections will have their elections set aside. But it's not so. It didn't fall within the bracket of what we can actually refer to as a pre-election matter. It also is not a matter before the tribunal, but it is validly a matter brought before the Federal High Court using the process of originating summons. And the court has done very well in the way it has made this declaration according to what it believes is the full interpretation of Section 77, subsection 3.
Well, let's see if Kehinde Edun is live now so that he can now also speak to us. Let's move on to Kehinde Edun, who is the legal advisor of the Labour Party. Kehinde, thanks for your time. Perhaps, if you will, let us in on what the Labour Party hopes to do in pursuit of this.
Very much for having me. Labour Party is not perturbed at all by this judgment order. We have looked at it and we have found out that it has not affected our fortunes in any way. It has not affected the fortunes of any of our elected candidates, and they are good to go. From May 29, our candidates, our elected governor in Abia, and members elect in the National Assembly, including our senators elect, House of Reps elect, House of Assemblies elect, they are going to be sworn in. They are going to occupy offices because this judgment has not affected us in any way. We have seen what has happened, what they filed before the court, and we have seen that, well, the court was misled to grant the order in the first place. And I want to also categorically state that the court itself said that it could not grant an order against Alex Otti or any of our members elected in Abia because they were not before the court. But the court should have also said that even members elect from other states, not even from Abia, not only from Abia, from other states, were not before the court. The defendants in that matter were only INEC and Labour Party. And let me say, Labour Party was never served with that process. And I cannot speak for INEC, but Labour Party, we were never served. I'm the National Legal Advisor, I'm the National Secretariat always. We did not receive any process. But in that court, we have a lawyer who was in Kano and got wind that some people were moving around in the court premises, and he was able to identify some of our suspended former national officers. So he knew that there could be some mischief and found out that they have filed the matter and that court said he was going to hear the matter. The lawyer filed a preliminary objection and objected to the jurisdiction of the court, but somehow, I don't know what happened. I don't know how the court rushed and said that he was not even going to allow the processes, he was not going to allow the processes filed by our lawyer, and said he was going to give judgment. But we have looked at the judgment and we have seen that in the first place, none of our elected members, the governor-elect was not a party, he was not a defendant. Our members, none of our members elect was a defendant, none of our senators elect, none of our House of Assembly members elect was a party, so that was a defendant. And it is clear, it is a general principle of natural justice that you don't condemn a man on heart, that you hear from the other side. So we are not perturbed at all by what has happened. We have not seen the judgment. We have only seen the judgment order that is flying around. We are going to get the judgment maybe by tomorrow latest, look at it. But we are going to file an appeal for it to be set aside for whatever it is worth. But I'm telling you, the judge only expressed an opinion about what he thinks the law is. But I want to state clearly that Labour Party, we've filed with INEC our register of members. We never shirk that responsibility. We filed our register of members, and it is in our province to say who our members are. A political party is supreme over its affairs. An issue of membership, it is the political party that can say, these are my members. All the members elect, including our governor-elect in Abia, including our Senate, all of them are members of the party and contested primaries. And in the first place, that matter of whether somebody was qualified to contest an election in the first place, this is a pre-election matter, for God's sake. These people, the contested primaries, their names were published since last year. For example, for governorship, I think around July last year, the names of those who were successful in our primaries and the primaries of other political parties were published by INEC. And if anybody had a reason to challenge their candidature, that person should have gone to court within 14 days of the occurrence of the event. So now, that matter, if they want to call it a pre-election matter, that they are challenging the emergence of our candidates, then the statute bad. That court has no jurisdiction to listen to them. And if they are saying it's a post-election matter, when a person has been elected as either a governor or a senator or a member of House of Rep or House of Assembly, the only way you can go to challenge that election is to go to an election tribunal. 7 days to the conduct of an election.
Apologies for butting in. I think I asked the same question of Frank Tietie earlier on, and I also bring that to you. But quickly here, unperturbed, you're not disturbed by the judgment, by the order.
Not at all. Not at all.
Quickly here, as soon as you're done studying this, what's the next move by your party, being the legal advisor of the Labour Party?
Yes, it's a judgment of a court. We are not going to ignore it. We are going to go there to challenge the judgment, file an appeal, make sure that judgment is set aside. Though we are not, there's no injury to us, but we are going to make sure that judgment is set aside. And we are going to present our case before the court. We filed our register of members, both electronic and hard copy, with INEC. And INEC observed while we comply with everything we needed to comply with before they attended our primaries, wrote a report on those primaries. Those candidates emerged validly. Their names were published by INEC. Their names were published from July 22. Names were published by October 4 last year. Finalists of candidates were published. If anybody had any reason to challenge their candidature, should have gone to court to challenge it. Another feature of that judgment is that how do you expect a court in Kano to now be giving judgment against Alex Otti, who was not in that court, who was not a party, and who was not from that place? It is strange. But I want to say that the judge even said it in his own judgments, that he couldn't give an order against Alex Otti and the members elect from Abia. I'm surprised that he did also say that even members elect from Kano and other places were also not before the court. I don't know who deceived the court, who misled the court, that the Labour Party was served. We were never served. But now that we have seen the order, for whatever it is worth, we are going to ensure that we file a notice of appeal to have it set aside, so that this thing will be put to rest. But we want to state that one of the things that this judgment has brought about is the mischief, and it is the harshest job that some of our suspended national officers have been sponsored to do.
I think you said that much earlier on. I'd like to thank you for your time, Kehinde Edun. Many thanks for speaking with us here on Newsnight, as well as Frank Tietie. Many thanks as always.